Welcome to a lecture on John Locke's Second Treatise of Government, 1690. By the end of these slides, you should be able to understand what natural law is and why civil government must respect natural law principles. To understand the positive law's connection to natural law principles and the subsequent obligations to follow these laws, and to be able to apply natural law principles to some contemporary, well, slavery is not contemporary, but some interesting cases that have come before the United States Supreme Court, like slavery, constitutionality of slavery, racial discrimination, affirmative action, death penalty, assisted suicide, and abortion. We're not going to touch on eminent domain. So, first things first, the date probably struck you, 1690. I mean, come on, Phil, right? This guy, John Locke, is going to establish some principles that we can apply to modern understanding of affirmative action and death penalty and abortion practices. Well, moralists believe that this is one of the central documents for approaching the interpretation of the Constitution. The second most important document is going to be the next lecture, which is Immanuel Kant's Metaphysics of Morals. And between understanding both Locke's and Kant's moral philosophy, we will then be able to have a foundation for how to approach interpretation of a policy, of a law, morally. And I think it needs to be said that it takes a while for ideas to percolate and to find expression in documents. And so the date 1690 took a while before it manifested in Thomas Paine's Common Sense and in the Declaration of Independence in 1776, and then the 1791 ratification of the United States Constitution certainly had a lot of Locke's natural law principles. And so this lecture will seem very familiar to you because you're an American citizen, because you understand that we have a right to life, liberty, and property, and is protected by our United States Constitution. But the ideas and their origins came from Locke and his clear articulation of why we need to respect natural law. So one of the major goals of this lecture is for you to identify the principle, the moral principle being affected by a law or policy, and to universalize that principle to all people. And so before we get to that ability to do that, what is this state of nature? What is natural law? Want of a common judge, a lack of a common judge with authority, puts all men in a state of nature. We're all here equally judging of each other. Is a state of equality wherein all the power and jurisdiction is reciprocal. No one has more power or jurisdiction than another. The state of nature has a law of nature to govern, and reason is that law which obliges everyone and teaches mankind that all being equal and independent, no one ought to harm another in his life, health, liberty, or possessions. Now, students of the United States Constitution hear in those last, that catalog of rights, the Fifth Amendment and the 14th Amendment. We all have equal access to life, liberty, property, and that cannot be taken away from us without due process of law. And students of the 14th Amendment will also hear that we're all in a state of equality, wherein the power and jurisdiction is reciprocal. We all have reciprocal access to equal treatment under the law in a state of nature. And so we hear the 14th Amendment's equal protection of the laws. So right away in this first paragraph from Locke, we have both the 5th and the 14th Amendments in a nutshell, where they come from. So the state of nature, this idea that man in a state of nature without government, really attacks the divine right of kings. Remember, Locke's British, and he's saying that, look, this idea that man is born with his divine right to rule over others is bogus. It also attacks caste systems, the idea that you're born into the untouchables in India and you cannot grow out of that class through the effort of your own labor, is to Locke absurd. It's a violation of natural law. Everybody has equal access to one's life, to, interestingly here, health care, right? Liberty, the freedom to choose what you do, and to one's property that has been justly earned. And so, because we all have equal access to it, and because we want it respected in ourselves, that is our life, equal access to life, liberty, and property, we must respect it in others. All right. Well, let's keep moving down the slide. So, all right, we're in a state of nature. Everything's equally reciprocal access, right to respect life, liberty, and property in others, why would we forego that right, that state of nature, and enter into civil government? The central reason is the last reason, to better protect our natural right, access to life, liberty, and property. There are some things we give up by going into the civil government, but what we gain far outweighs what we give up. And what we gain is better protection by the police force, by an independent judiciary of those who want to violate our life or have violated our life, liberty, or property. We also want to avoid a state of war. And a state of war is a state ungoverned by reason, a state in which force governs all and not reasons. We want to establish common right and wrong, that our laws are grounded in reasons, and we all know that other people will respect and can at least have access to the ability to be able to follow those laws. And natural law is then backed by force the individual can provide. I mean, think about the police force and the ability of the courts to punish far outweighs your ability to judge and punish in a state of nature with your rock in your hands. But one of the things we give up is that it separates you as the judger of others and the punisher of others. And you give that, by entering a civil government, over to the police force, over to the law, over to the independent judiciary. So to avoid a state of war, we enter in a civil government that is grounded in laws that are based on reason. All right. So this is the first question I want you to answer in your Google Journal. You can press pause and go back to certain slides to answer the question. But what moral principle or natural law principle informs your understanding of the 5th and 14th Amendments' protection of individual life, liberty, and property from any unjust governmental action? So what is it? What is that? What is the principle that forces one to respect the life of another, the liberty of another, and the property of another, and for them to respect yours? I'll take you back to a quote that will help. Press pause and write your answer in your Google Journal. Well, hopefully your answer had something about reciprocal equality, the idea that we all have this equal access to our life, to liberty, and to property, and because we expect it to be respected in ourselves, we must respect it in others. All right. What power does natural law invest in man? Well, he argues that the power to preserve one's station and to judge of others. Man being born, he wrote, has been proved with a title to perfect freedom and an uncontrolled enjoyment of all the rights and privileges of the law of nature. So that's our state of nature. We're all born with perfect freedom. Equally with any other man or number of men in the world, hath by nature a power, hath by nature, that means grounded in the nature of things, implicit in existence, a power not only to preserve his property, that is his life, liberty, and estate, against the injuries and attempts of other men, but to judge of and punish the breaches of that law in others, as he is persuaded the offense deserves. So, in a nutshell, in a state of nature, if someone violates your life, liberty, or property, or attempts at your life, you have the power to judge of them, and you have the power to punish them. And as I've argued, you give up that power when you enter a civil government, and you give it over to the independent judiciary. He argues here one of the central principles of the Second Treatise of Government in 1690 is that the only legitimate government, the only government that is in keeping with the principles of natural law, with the principles of reason, is government by consent. He wrote, famously, man being, as has been said, by nature all free, equal, and independent, no one can be put out of this estate and subjected to the political power of another without his own consent. The only way whereby anyone divests himself of his natural liberty and puts on the bonds of civil society is by agreeing with other men to join and unite into a community for their comfortable, safe, and peaceful living, one amongst another, in a secure enjoyment of their properties and a greater security against any that are not of it. And so you cannot willfully be put out of your right to life, liberty, and property. I'm sorry, let me back up. No one can be put out of this independent state without consent. And so you cannot leave your state of nature where you have equal access to life, liberty, and property without consenting to do so. So tyrannical rule, dictatorships are violations of natural law. And slavery, as we'll find in the next slide, also is a violation of natural law principles. And so he wrote, and hence it is that he who attempts to get another man into his absolute power, whether a dictator or a slave owner, does thereby put himself into a state of war with that person, it being to be understood as a declaration of a design upon his life. For I have reason to conclude that he who would get me into his power without my consent, dictatorship or as a slave, would use me as he pleased when he'd got me there, and destroy me too when he had fancy to it, when he desired to do it. For nobody can desire to have me in his absolute power unless it be to compel me by force to that which is against the right of my freedom, make me a slave. To be free from such force is the only security of my preservation, and reason bids me look on him as an enemy to my preservation, who would take away that freedom which is the fence to it, and he who makes an attempt to enslave me thereby puts himself into a state of war with me. So this is a key idea. There's a state of nature, equal reciprocal access to life, liberty, and property, and there's a state of war. And the state of war, remember, is governed without reason. So unreasonable violations of life, liberty, and property backed by force. Slavery does that. There's no justifiable reason for slavery, violation of natural law. Dictatorships do that. That is force and law posited by force and not reason. Okay, so another moment to add to your Google Journal. What moral principle disallows the institution of slavery and tyrannical rule? And then, secondly, does this make the 1791 Constitution's positive law that allowed for slavery? Remember, the ratification in 1791 continued the institution of slavery, as we know, until 1865. Does that make it incommensurate with natural law? Well, that's bizarre, right? Is the Constitution's, which is grounded in Lockean natural law principles, how could it allow slavery? Does the fugitive slave law, or the continuation of slavery in the Constitution, make it incommensurate with the very principles that supported most of it? Have it press pause and take a look at some of those slides, like this one, that will help you answer the question. Well, now that you're back, hopefully you had something in your answers along the lines of that, restrictions of freedom must be grounded in reason and not in arbitrary attributes. And restrictions of freedom, that is, the ability to govern, must be grounded in consent. That shows you why tyrannical rule or dictatorship is wrong. Is the Constitution contradictory with positive and natural law? Yes, in a nutshell. The positive law of the Constitution was in conflict with natural law principles that inspired it. But the Founding Fathers, some argue, could foresee a day when the positive and natural law would align in an amendable Constitution. That is, even implicit in the 1808 discontinuation of the importation of slaves, which is in the Constitution, foresees a day when the natural law principles of equal access to liberty and reciprocal obligation to respect the liberty of others, that there would be a day that the Constitution would be amended, and it was, by the 14th Amendment. I'm sorry, the 13th Amendment, which disallowed slavery, and the 14th Amendment, which guaranteed rights to African Americans, that it would be, that the positive law of the Constitution would be in keeping with the natural law. And so we got there. It took a while, took 100 years, nearly, but we got there. All right. Let's keep moving. From where do we derive this equality in the state of nature? And for Locke, he argues that we get it from the infinitely wise Maker, from God. Because we were sent into the world by God's order. Man is God's property, whose workmanship they are. And sharing like faculties, there cannot be any subordination among us. Everyone is bound to preserve himself and not quit his own station willfully. That is, he cannot take his own life willfully. And so by like reason, wherein his own preservation comes not in competition, that is, we all have this natural law right to self-preservation. When our own preservation comes out in competition, we ought to preserve the rest of mankind, and life, liberty, health, limb, and goods of another. And so in here we have this idea that we are not, our bodies are not our own, our minds are not our own. God gives us reason, God gives us our bodies, and we are of His property, and therefore we cannot, two things, quit our own lives, cannot commit suicide, or allow for others to assist in suicide, and we cannot allow for subordination among us. because we all have equal access to life, liberty, goods, / property. Why? Because reason, the common rule and measure God has given mankind, commands that man ought to preserve the rest of mankind and his own life, liberty, limbs, and goods of another. Okay, and so this is interesting. So Locke puts it in God. We get this ability to reason from God. Our bodies come from God. Our minds come from God, and therefore there cannot be subordination among us, and therefore we cannot take our own lives or the lives of another. And then Kant comes around, you'll see in the next lecture, and he says, look, we have this reason. I don't know. Maybe God gave it to us. Doesn't matter. We have it. And reason requires us, obliges us to preserve our own lives and the lives of others. It's an interesting distinction. The executive power of the law of nature, right? The obligation to right or wrong. If anyone offends, he argues, against the law of nature, everyone else has the right to punish him for it and exact retribution, not simply for his own damage, but to vindicate the rule of reason and common equity. Okay? And so the executive power of the law of nature is the idea that we can execute upon violations of natural law, violations of law that is grounded in reasonable principles. And so there we have this idea that law is violent. Law can punish, can vindicate those who violate. All right. What does freedom mean, according to John Locke, in a civil government? He writes, the natural liberty of man is to be free from any superior power on earth, and not to be under the will or the legislative authority of man, but to have only the law of nature for his rule. The liberty of man in society is to be under no other legislative power but that established by consent in the Commonwealth, nor under the dominion of any will or restraint of any law, but that the legislative shall enact according to the trust put in it. So there's this idea that the only legitimate government is one that is gains its power from consent. What does freedom mean under government? Freedom is not for everyone to do what he lists, to live as he pleases, and not to be tied to any laws, but freedom in a civil government is to have a standing rule to live by, common to every one of that society, and made by the legislative power erected in it. Legislative power comes from consent of the people. A liberty to follow my own will in all things, wherein the rule prescribes not, and not to be subject to the inconstant, uncertain, unknown, arbitrary will of another man, which is the state of war. That's freedom of nature, to be under no restraint but the law of nature. So, freedom is not to do whatever you want, whenever you want. I mean, peace out, man, from the 1960s. Freedom in a civil government is this idea that we all share this common understanding of right and wrong, which our laws support. And so that is freedom. Freedom because we are restricted in certain things. All right, another opportunity for you to add to your Google journal. Does Locke's view that it's God-given reason, God-given equal faculties in man, that allows man to be treated equally and respect equality in others and judge and punish others, does that diminish or enhance the power of natural law in your view? Remember, Kant's going to divorce it from God. But how about that one? And the second one, these are different here. From where does the judicial branch of government derive its authority to punish? Right? Why? What's the moral principle in the state of nature that states that allows governments, the judicial branch of government, the police power in government, to punish? Hint, it's in this quote. Right here. All right, back to the question. If a positive law like the fugitive slave law does not follow the moral principles of natural law, are you obliged to follow that positive law? All right, press pause and have at those. Hopefully your answers to the first one had something to do with if you think it diminishes it, that Americans believe in the separation of church and state and that God should not be a justification for certain laws. If you believe it enhances it, your answer should have something along the lines of that the idea that a divine force is behind equality and behind reason, that God has given us these things, enhances our respect for reciprocal equality. The second question, where does government derive its right to punish? It derives its right to punish because in a state of nature, one has the ability to defend one's natural rights and punish those violations of one's natural rights. And the last question is, do you have a right to resist a positive law that doesn't follow natural law? Yes, absolutely. Civil disobedience. Martin Luther King did so when he was civilly resisting violations of African Americans' natural rights. Okay, now we're getting into the sort of the modern ideas that have plagued the Supreme Court as of late, and that is the constitutionality of affirmative action. How would a moralist, through Lockean natural philosophy, approach affirmative action? What did he say about it? Well, he said that all private judgment of every particular member being excluded, the community comes to be the umpire by settled standing rules, indifferent, and the same to all parties. So principles, rules, must be applied in the same manner to all members of a civil government. And he goes on to say, they are to be governed by promulgated established laws, not to be varied in particular cases, but to have one rule for the rich and the poor, for the favorite at the court, and the countryman at the plow. So how does this apply to affirmative action? Well, in affirmative action, there are positive judgments, or adverse judgments, depending on how you look at it, based upon an arbitrary attribute like race. And so, implicit in this language here is that that principle that one should be treated equally before the law, and that arbitrary attributes like race shouldn't diminish one's equal treatment, is a violation of natural law. There's one rule for the rich and the poor, there's one rule for the black and the white, and there's one rule for the favorite at the court and the farmer at the plow. So, have at it on your Google journal. According to Lockean natural law philosophy, what moral principle is violated by affirmative action? Press pause. You want to have a look back here to establish the moral principle that is violated by certain affirmative action policies. Well, welcome back. Hopefully your answer has something along the lines of that one cannot make positive or adverse judgments based on arbitrary factors, and that we have one common shared principle that applies to all citizens, rich and poor, black and white, farmers and favorites at the court. However, current affirmative action policies are make positive judgments based on meritorious aspects of one's application. That is the ability of an underrepresented minority to contribute to educational diversity. All right, let's keep cruising along and let's get to Locke's moral philosophy and abortion. He wrote, "The freedom from absolute arbitrary power is so necessary to and closely joined with man's preservation that he cannot part with it but by what forfeits his preservation and life together. For a man, not having the power of his own life," remember we are of God's property, "cannot, by compact of his own consent, enslave himself to anyone, nor put himself under the absolute arbitrary power of another, to take away his life when he pleases. Nobody can give more power than he has himself, and he that cannot take away his own life cannot give another power over it." So here we have this understanding of why slavery is wrong, the understanding of why tyrannical or dictatorship rule is wrong, but we also have this understanding in this language as to why man does not have power over his own life, that life is sacred, it is God-given, according to Locke, and we do not have power over it, so therefore we cannot give one another power over it. So here we have an implication that assisted suicide is wrong, and that if we can see that the fetus is a life upon conception, and then taking out that life is wrong. So what moral principle informs Locke's statement that innocent life cannot be taken by arbitrary powers of others or oneself? Why do we not have the power to take the innocent life of others? And how does this then logically extend to preventing us from taking our own lives? Or vice versa, how does the idea that we cannot take our own life lead to the idea that we cannot grant that power to take our life to others? And then, finally, what moral principle, according to the Locke natural law, is violated by abortion, if you can see that the fetus is an innocent life? And there's the quote there that can help. "Man sharing like faculties, there cannot be subordination among us. Everyone is bound to preserve himself, and not quit his own station willfully, and so by like reason, when his preservation comes not in competition, ought to preserve the rest of mankind in life, liberty, and all the goods of another." And also this quote will help you as well. Press pause and add to your Google journal. Welcome back. Hopefully your answers had something along the lines of, reasonless creatures, man and beast, can be destroyed, right? But innocent creatures, those that have not committed a wrong, their lives cannot be taken. You don't have the power over your own life. Life is sacred, and therefore you cannot quit your own station, so you cannot grant the power for others to take your own life, assisted suicide, and you cannot grant the power to others to take an innocent life away through abortion. And let's end with the death penalty. So very quickly, what are the justifications for killing? According to Lockean philosophy, self-defense, war, prevention of imminent deaths of others, which is related to self-defense, and capital punishment. He makes the argument that the safety of the innocent is to be preferred, and one may destroy a man who makes war upon him, or has discovered an enmity, a hatred to his being that threatens his life, for the same reason that he may kill a wolf or a lion, because such men are not under the ties of common law of reason and have no other rule but that of force and violence, and may be treated as beasts of prey, those dangerous, noxious creatures that will be sure to destroy him whenever he falls into their power. And so the point here is that there are justifications for killing. Self-defense, everybody understands, right? You have this obligation for self-preservation. And if somebody threatens your life unjustly, you can respond with lethal force, right? Everybody understands that. Well, the same thing goes for the third principle. If there are imminent deaths of others, of innocents, then you have the right to take that person out. Well, war. Now, why is war justified? Locke makes the argument that under the command of officers, soldiers don't have the ability to reason. They don't have the ability to decide what is right and what is wrong necessarily. They are commanded to do certain things, and so therefore they have sort of been subordinated, if you will, to like a wolf or a lion or a bear that wants to take you out. And because they're not governed by reason, and only governed by force and command, you have the ability to resist and to take their lives. Now, capital punishment needs some fleshing out. He writes, there's a power not only to preserve his own property in natural law, his life, liberty, and estate, against the injuries and attempts of other men, but to judge of and punish the breaches of the law in others, right? This is the executive power of nature. As he has persuaded the offense deserves, even with death itself, he argues, in crimes where the heinousness of the fact, in his opinion, requires it. Once a man willfully has taken the life of another without justification, he has forfeited his right to his own, he famously wrote. Those who prey brutally and purposely upon their fellow man invite by their own deeds society's absolute punishment. The degree to which a society respects the sanctity of life is manifested in its readiness to justly take the life of another, of one who has unjustly taken life. Such a severe penalty is not invoked with joy, but with justice. And so this is the famous argument for the death penalty that is in our Fifth Amendment, right? The government cannot take away your life, liberty, or property without due process. But through due process, the government, the state government, and the federal government can take away your life, can execute capital punishment, the death penalty. Why is that? The argument here, as he says in the bottom paragraph, is that once you have unjustly taken the life of another, once you've violated that sanctity of life, that natural law right to life, you have subordinated yourself in through that action so that the civil government does not need to respect your natural right to your life. It's the only deed that is so heinous that takes away your right to life. And so, why does natural law allow civil government to take the life of a convicted murderer of innocent life and disallow abortion? That's going to take some thinking, so you got to go back to a couple slides, right? What is his reason? What is Locke's natural law reasoning for the death penalty, and how is that in the same breath in keeping with his disallowing abortion? What's the difference between the fetus and the convicted murderer? And do you agree that natural law principle that prescribes the civil government from the taking of innocent life by necessity allows for capital punishment in order to respect the sanctity of innocent life? So take some time, look at the death penalty justification, look at the death penalty justification here as well, and then look at the justification for why one cannot give the power to an abortion doctor to take away innocent life. Take you back to the questions. All right. Well, you have lots of answers, and hopefully your Google Journal along the lines here has something to say about the idea that the fetus is an innocent life, and we must respect and honor that life, whereas the convicted murderer, through his heinous act of unjustly taking the life of another, has subordinated himself, and he has foregone his right to life. And we'll just leave it there. Do you agree? It's up to you. Do you agree the natural law principle that prescribes civil government from taking an innocent life by necessity allows for capital punishment in order to respect the sanctity of innocent life? Well, they're related here, right? They're both, abortion and capital punishment and death penalty, both have this idea that innocent life is sacred. Innocent life must be protected at all costs. Death penalty certainly respects that, and preventing abortion, the taking of an innocent life, certainly respects that. Thanks for listening. I know that's a lot of information, so you may want to go through and review some of these things, but your Google Journal should give you a chance to work through some of these ideas and apply them to the Supreme Court's ideas on capital punishment, Supreme Court's ideas on abortion, and the Supreme Court's ideas on affirmative action. More on Kant in the next lecture to finish the foundation for the moral approach to constitutional interpretation.